This is an IA which I had filed in a disposed of matter, Your Lordship. Now, on 8th of February 2024, Your Lordships were pleased to give the mother telephonic access twice a week. That Your Lordship will find
Yes, but
at which
Lordship, this copy has been wrongly served to us, Lordship. We have no contact with the opposite party number one, Lordship. Since this is disposal of matter, we took all. Yes, Lordship.
because now admission has been given, we've given her admission in a boarding school in Mussoorie International School, where the session has started from April. So the school has its own
What
regulation.
jurisdiction have you approached, sir?
My lord,
What is the jurisdiction?
my lord, this is a dispose of matter, no doubt about that.
No, what is the jurisdiction you're trying to invoke?
My lord, I actually beg to rely upon, my lord, a Supreme Court order which says that when a matter, even if it is disposed of, and the order is executory in nature, and subsequent developments have taken place, which makes the implementation of the
You're
order
referring to
impossible.
Jaipur order.
Jaipur, that
Vidut.
one, and the more recent one of December 24, which is Ajay Kumar
Ajay
Jain
Kumar
versus
Jain.
State of Uttar Pradesh. So that clearly, my lord, brings me within the fold of the limited
We don't
jurisdiction.
think so.
My lord, may I just hand
That
over?
is neither you are asking for extension of time for execution of the order, nor any subsequent development. It's a new course of action. This food is not before us.
No, my
How
lord,
are you
I
affected?
have placed on record, my lord, the documents, the admission documents also. My lord, I'm,
The Fukansi, we are not saying that you are remediless. We leave you remediless.
my
You
lord.
can approach this court in the appropriate jurisdiction.
No, my lord, I don't want to be seen to be violating your lordship's order. That's why I have moved this IA, my lord. Because otherwise,
Are you violating, you are seeking some directions
modification.
from us.
I'm seeking modification, my lord. My lord, may I just show one paragraph
Yeah,
from,
this court in the appropriate jurisdiction is sin.
my lord, because a custody proceeding is pending in Dibrugarh, and the custody proceeding I had filed for custody of my daughter in 21,
This may be
and she
relevant matters,
has
but
been dragged.
This may be relevant matters, but the matter has been, the petition has been disposed of.
No, I bow down completely. I bow down, my lord.
For extension of time or some food, some visiting rights, telephone rights. This is a very
No, no.
trivial kind of a thing.
I bow down completely, my lord, but I don't want to be seen to be violating the court's order, my lord. That's my only concern. I'll just read one paragraph from this order, my lord. Yes, my lord. Paragraph 17. After sort of extracting Jaipur Vidut, which my lord Justice Medhi had pointed out, at paragraph 17, the court says, thus, this court made it abundantly clear that a miscellaneous application filed in a disposed of proceedings would be maintainable only for the purpose of correcting any clerical. My lord?
It has been settled long back.
Yes, yes. So I'm saying, my lord, the second sentence
Mr.
here,
Fukan,
my lord,
have you got the Brahmadat case?
my lord. No, I don't have it, my lord. My lord,
87.
my lord.
You look into Brahmadat, this will not be maintainable. And you also look into K answer, it is a judgment K answer with Indian Airlines, if you remember. It is not an absolute bar.
My lord.
K answer may give you still a window to approach us, but it will not fall under. In fact, the Vidut case, Jaipur, something has been said that it's not an absolute bar.
No, here, this is the second sentence where I am trying to bring my case within that, my lord. It says that if the order is executable in nature, and my lord, then there are circumstances, subsequent developments, which makes it impossible to implement that order, then the party can come, my lord, through a IA.
What is your difficulty in implementation? Who are you?
No, I am not I'm, my lord,
Who are you? Was it to be executed by you?
my lord, telephonic access was to be given, and she was in my custody at that point of time. Now, my lord, the change in circumstances, at least, my lord, I have to bring that to your lordship's attention.
Let them come, that there is a violation by
No,
you.
they have, my lord. They have already come, my lord.
Well,
And a contempt notice also has been issued. That was filed subsequently. In fact,
that's your defense.
my lord, may I just hand over this order? In fact, I had filed this immediately after the session began, my lord, but because of the bench, my lord, being not available, I mentioned it also. And then that's how we filed it on 25th of April itself. We had filed the IA, my lord. The session had started.
You take this as a defense in your contempt case.
I will definitely, my lord, I will definitely take, my lord, but this I had filed before, my lord, the contempt was initiated. Contempt order is of 16th of May. I had filed this, my lord, with all bona fides, my lord. I had come to this honorable court immediately after the session had started in the new school, my lord. And because it's a boarding school, initially for 1 month, my lord, they have no telephonic access at all. After 1 month, it's only once a week that the
But
girl.
this would be the concern of the school, that we cannot give a telephonic access. This is against our rules.
My
Let
lord.
the school
No,
come
but,
for us.
but my lord's order is operative, it's binding on me as well, my lord,
This-
as a father.
That part is not within your bounds.
My lord, may I just read your lordship's order, if your lordship permits me?
That
Yeah,
is not
page,
within your bound.
my
Why
lord,
are you so concerned?
no, I am concerned because I felt, my lord, this is a binding order, my lord, operative on me, my lord. And I was also obliged to ensure that telephonic access is to be given, my lord. That's at paragraph 6 of your lordship's order at page 31. What your lordship said, my lord, at paragraph 6. What your lordship said at paragraph 6, with respect, may I just point out the operative portion of your lordship's order? Paragraph 6, my lord, at page 31. After your lordship actually had an interaction with the child, also in camera proceedings happened. And in the habeas corpus, they had moved an IA, my lord, for telephonic access. Where your lordship said at paragraph 6, however, on considering the prayer, this is at page 31 I'm reading. However, on considering the prayer made in the IA, this court is of the opinion that telephonic access to the applicant mother is required, taking into consideration the welfare of the minor child.
That's
In
not-
this, my lord. What my lord said was that the applicant mother would be allowed to have telephonic access to the minor daughter twice a week, namely Tuesday and Friday between so and so and so and so. Now, that is what I'm not able to comply with today, my lord. That's my bona fide submission, my lord.
It will not affect you if she is in the school. We don't think we should entertain this.
My lord may at least protect me so that, my lord,
Now you take this defense, we can.
I will certainly take it, my lord, in the.
We'll make some observation. We're approving this. We'll be discussing this in some observation.
My lord may take note of the fact, my lord, that she has been admitted to a new school because I have produced.
That will not.
My lord, and may I just hand over a letter also, which actually the school has written.
We don't find your.
No, no, my
petition,
lord,
your
my lord,
doctors-
my lord,
your
I leave
doctors,
it.
Not on the aspect of a disposal of petition.
I
Your
bow down.
doctors, Even with the merits, but we're not saying anything.
I bow down to
If there is any complaint, it has to be from the mother. Let her come saying that in spite of the decision, I've not been given access, and for that you are responsible. That is not the case. Mother is not before us.
No, my
We
lord,
should not be affected.
all that I wish to point out is since your lordship will be making some observations, your lordship may take note of this letter from the school.
Is it a part of the?
No,
record?
this came subsequently, my lord, because this we had filed on
We cannot-
25th
we cannot-
April.
we cannot
Because the
say.
school, my lord, the telephonic access that the school gives,
See,
my lord, is only.
on principle, we are against you regarding the admissibility or intentability of this petition itself. In spite of that, we are saying that we'll make some observation which might benefit you if any proceedings are pending.
But all that I would submit regarding the maintainability is what I had already stated, Milord, because I respectfully, Milord, come within the
Well, record.
observations made by the Supreme Court.
Criminal petition for admission now. On Friday or on Monday, my lord, any date, please.
Seventeenth.
17. Oblige.
May it please the lordship, lordship, with regard to item number 3, lordship, I may be allowed to go to the records, lordship. Item number 3.
Oblige, your lord.
May I present, Lordship, I beg to mention for listing an iron in criminal appeal, my lord. In this case, from the same judgment, co-accused are already released on bail. Thereby, I am praying on Monday, my lord, 16, my lord.
When did you file the IA?
It was a long pending, my lord. Objection was also filed by the Mr.
Okay. Done.
I have another prayer, my lord. Item number 4, my lord. Madam, you pass over for that day, my lord. Fix on, my lord, next week, my lord, 17, 18.
19th.
Master place, my lord.
May I please the lordship? I beg to mention listing of a criminal revision petition, lordship.
Criminal division petition not before this.
Next for, it may be taken up next week, lordship. Arguing counsel will come from Delhi, lordship.
Friday, 20th, 20.
Much obliged, lordship.
For listing of an anticipated bail application, Lordship, and day after tomorrow, Lordship.
When did you file?
Yesterday, Lordship.
You have the filing number with you?
Yes, yes.
Okay.
Oblige.
I beg to mention that for listing, my lord, I a criminal in criminal appeal, my lord, before 17 N.
Make it on 17th.
17.
Wait, wait, I beg to mention a criminal petition, Lordship. Any date next week, it was last listed on 26/5, and it was directed to be listed after a week. Lordship, any date next week.
18th.
Lordship, oblige.
My please, Lordship.
Take your seat. Mr. Sharma, one of the accused was released on bail because of non-compliance of section 50 of it. The specific direction while granting bail was that he shall will remain present before the court in every day when it is fixed. After his bail, he appeared only once. Till the month of June first part, the said accused did not appear. And prosecution is silent. This is clear violation of the order of the court granting bail to the accused.
That is happening on a lot.
How can it be possible? How can it be possible? Just tell us. Where is Mr. Gogoi? Public prosecutor. He will be available somewhere near that.
Yeah.
In some.
We will also have to inform the prosecution department also. Okay. Yes.
Mr. Gogoi just have informed Mr. Sharma about it.
Yes, sir. Yes, immediately.
Because of the constitutional violation,
Yes,
the accused from whom accused number of
yes,
NDPS items have been recovered, they have to be released on bail.
yes.
While going to the records, we found that one of the accused was granted bail because of non-compliance with the provision of section 50 of the One of the bail condition was that he shall appear before the court on every day. When the matter is fixed. After his bail in May 2025, he only appeared only once,
Yes,
but thereafter he did not appear.
yes. So
This
let's
is
see,
for
we have,
your information.
we have to
That is
fight.
why I wanted to tell.
Yes, sir.
Just tell us one thing. Are you getting your remuneration every month?
Yes. Some fault is in our office, yes, because the senior government office only send the losses that when the fund is available, that part they have. Yesterday I have talked with the losses, senior government advocate losses.
Are not they complying with the orders of the court? The division bench judgment, of-
Loss, loss,
they are not complying, your office is not complying with that.
loss. I today, I will- today, I will- today, I will talk with him. Today, I will talk with him.
How many months have to be paid?
Almost 8 months, 8 to 9 months.
Okay.
Yes.
Or Mr. S. Rahman. Okay, that's only for the information of Sachin people being the public prosecutor.
Loss,
There is a case where it is matter is pending before the Kamruk Metro only,
loss.
but from the order
So,
set,
yeah,
it
I-
reflects that
I
Did
will
not
from the
appear.
prosecution department, I will. Obligation. এই বস্তুটো আমি রাখছেন গোটা কোড নম্বর 5
yes, yes, you proceed only for you, that information we
let's-
wanted to give, that's all.
obligation.
And Mr. B. Sharma. More ta or ta to kichu more property. Where is the earlier rejection order, Mr. Rahman? Which page?
Page number 6 and para number 6, I
Hmm?
mentioned number. Page number 6, para number 6. Page number 6 and para number 6.
Order, not next. You have not annexed.
Yes, no, no, mention it. And
In this application. Or with his bail. The petitioner contained the one of the co-accused Vidyanath Singh, BIDY, arrested together with the petitioner and another namely Sandeep K. Pharma, SMD. Were granted bail by a coordinate bench of this court on 03042025. Connected bail application number 2656 of the 2025. As at the time of his arrest, the authority of Guwahati JRPS did not comply with the provision of section 50 of the CRPC thereby violated fundamental rights guarantee. Petitioner. With that. Mr. Counsel appearing for the petitioner. Also submitted. What does it also submit? That. Even in his case. The authorities of Guwahati JRPS did not comply with the provision of section 50 of this. Where was the records of the case that was called for? Records of NTPS case number 22 of the group. Arising out of Guwahati JRPS case number 207. As well as records. As well as the record. So it's called for by order. On perusal of the same. It seems that similar notice under section 50 CRPC was also served on the petitioner on 13/10/2023 while he was arrested in Guwahati JRPS case number 207, which he received, which and he received and gave acknowledgement. But on perusal of the said notice, issued under section 56, to the petition, it is seen that it is not important.
Bless.
May please, Your Lordship. My lord,
Yes,
but
just tell us whether someone is appearing or what? You are appearing.
Lord, behind, the accused is behind the bar since for 49 days, my lord. And my lord, her mother has shown an affidavit that it was misunderstanding. That's why the case was filed and she has no objection, he grants bail. Now, my submission is this, my lord. She's a widow and she was under compulsion of some leading persons to squeeze money from the accused. So, my lord, sufficient time he has been in custody and case is also charge-sheeted. I will face trial, kindly grant me bail.
I want to make two submissions also. Firstly, Lordship, what he is stating, Lordship, is that the mother has lodged the FIR, Lordship. It is not true, Lordship.
No, no,
The victim has lodged the FIR, Lordship.
yes.
And Lordship,
Mother has shown affidavit.
no, she has no authority, Lordship, as per my statement, Lordship. The FIR has been lodged by the victim herself, Lordship, and she was around 13 years of age, Lordship. 164 she has indicated. Next is, Lordship, the offences which is under trial, Lordship. These are serious offences, Lordship, that cannot be compromised in such a manner, Lordship. And next submission is, Lordship, the case is already, Lordship, it is fixed for. Trial has started, Lordship, the victim can appear, Lordship, and say the same facts, Lordship, before the trial court. That he is entitled to bail, Lordship.
My lord, kindly see page 18, my lord. Charge sheet is filed under section 8, not 4. And punishment under section 8 is 3 to 5 years. That maximum it may be up to 5 years. So it is not 4, my lord. Page 18, kindly see.
74 is also there.
I am not saying there may be allegations, but when the victim's mother herself has stated, and my lord, she has also engaged lawyer. So my submission is this, my lord, 49 days in custody, and what more they will get? I will face the trial. And charge sheet is filed under section 8. And medical report, my lord, that is nil. That is nothing violence was found. So that is also a ground for consideration, my lord. Sure. It is also 5 years. Mm. My lord, this, another thing, my lord, section 74, which my learned friend has pointed out, that is also just like section 8 of POXO Act, 3 to 5 years. And as there is the affidavit, no objection, that no objection in granting bail. So I think your lordship may kindly consider these aspects.
Could not kindly page the order dated 24/4/25, the bail rejection order. It was for an amendment.
My lord, kindly see page 22, my lord. Order of the learned special judge, where he said, my lord, no injury found on the bodies of the accused persons as per medical report. And my lord, here is also stated that she is a poor person. And lastly, my lord, the order dated 24/4/25, page 23. Kindly see here the learned judge said that here in this case, that the learned counsel for the accused submitted an affidavit shown by the mother of the victim, but the said person was not found present on call. Moreover, it is seen that FIR case is lost by victim herself. She has also not appeared before this court. So now that condition has now been fulfilled because she is before your lordship, my lord. Actually, they have committed mistake. On that day, if the mother and the victim would have been produced before the trial, that court, perhaps bail would have been granted. So reason is given, they are not present. But today, they are present before your lordship, my lord. Page 23. That order was filed after your lordship's order. That has been quoted in the order itself.
Heard, Mr. Counsel appearing for the petition. Yes, what do you have to say?
My lord, that is not to occur.
And Mr. B. Sharma, an additional public prosecutor appearing for the state. Also heard Mr. A. Islam, M. Ali, right? Learned counsel for the
Respondent number 2.
respondent number 2. Petitioner, namely such and such, is a such-stated accused in special within bracket POCSO, bracket close case number 14, within bracket BZ and no, BK, public 2025. Under section 137, bracket 2/74, public 115 within bracket 2,
TPNS Ready Section 8 of the PSUSU Act. Arising out of Manipur Police Station case number 132 of 2024. Petitioner has filed this application under section 483 for his weight in the same special circumstances on 05/05/2025. Stating that earlier he approached this court on 2 occasions, praying for his prayers bail in said Manipur PS case number such and such. However, on good day of Manipur PS case number such and such. In AB number 14/2025. As well as AB number 380/20. In AB number 14/2025. His clearance bill application was registered by this court on 07/01/2024. And in his second clearance bill application. In AB number 380/2025. While rejecting his case for clearance bail, the court directed him to approach the Court of Learned Special Judge Poksu Bongaigaon for his regular bail as in said case, the search of so. In order to 25 pages. Second. AB 380. Later, he was taken into custody by police and was produced before the Court of Learned Special Judge Poksu Bongaigaon on 24/04/2024. And he is in custody in the same special Poksu case number such and such. Arising out of Manipur. Petitioner submitted that the that on 11/02/2002, mother of the victim girl sworn an affidavit stating that the affair was lodged, affair pertaining to Manipur case due to misunderstanding and ill advice against the petition. And if the court allows the petitioner to go on bail, she will have no objection. And this bail application by the victim. Such and such.
As for the FIR. Dated. Twenty-eight 11/2024. Laws before Manipur Police Station. The case is that the victim girl and the petitioner are known to each other. On the night of 09/11/2024, the accused petitioner induced the victim girl and took her in his bike forcefully. And committed rape on her. At Sonaipula field. Then he took her to the house of one Abu Sama of Sonaipula village. On 10/11/2024, morning around 7, he forcefully took her
Wait, your lordship. The petitioner is behind the bar for the last 60.
He's appearing for the victim.
Lordship, the office note suggests that service report is awaited.
My lord, I have instructions to appear, but the vocality is not. Right. Mr. Bhatta, tell us when, Monday?
Lord, we have talked to Mr. Senior Counsel. Can it be taken up on next Friday?
Next Friday, 20th. Mr. Dutch.
Obliged.
Art, Mr. P. J. Sekal and Senior Counsel. Assisted by Mr. P. Bordole, Counsel appearing for the petition. Also Hart, Mr. Also, and Mr. B. Sharma and additional public prosecutor appearing for the state. And Counsel 40 of the party number 2. Father of the victim.
Obliged.
We have
Lordship, 28 is also fixed for evidence in the court below.
But they wants to have.
Oblige.
Five Lordship, charge sheet has been submitted.
Charge sheet submitted
Yes,
against the petitioner.
yes.
Only give us the number.
Charge sheet number 78/25 dated 30 April 25.
May I put the appropriate please?
Mid-period. But there was an earlier order also in writ petition number 601 of 2017, directed by this honorable court to bring Miller to forward the annexer, yes, whether this form A by the response number 3. This order may kindly query.
In which case?
In 601/2017, order dated 13/2017. Specific
601.
direct- specific direction was there, my lord, in 2017.
Now tell us when this format A was forwarded. When format A was forwarded. Because that principle is no longer there.
Yes,
So tell
But-
us,
from the page 15, my lord, it was on 23/05/2016,
case 15 of
15 of this review petition. It is the inspector of schools, my lord, Borpeta District Circle.
page 15
Yes, yes,
forwarded by.
below, my lord. Signature of principal is also there.
That is only from the Borpeta side. Whatever the school in which you have been serving.
That was directed by this honorable court as per,
Is the reason we are asking you, Mr. Kuchani, when it was forwarded by your school.
my
When
lord,
it
this,
was forwarded by your school.
this petitioner could not go to the school, my lord, therefore this by honorable court.
Basically, that is the reason we are asking you. That part is already over, right? That person against whom there was a sexual
Yes.
allegation of sexual harassment and there was an allegation, that part is already over. That person is no longer there.
Yes,
Then what happened? You did not go to school alone, that means.
the chief petitioner could not go to the school, my lord, because it's a group of persons there.
That is the reason we are asking you. Kindly tell us, because for review of disorder, you have to tell us when this format A has been forwarded by the principal of the school in which we used to work. When it was.
Now, that is to be answered by the response number 3, my lord.
So in the affidavit filed by the commissioner, it was clearly mentioned that there was no such format A for your transfer, inter-district transfer.
That was the
That
duty
is
of
why
the,
that order was passed, but unless you establish that format A was already issued and that has not been considered, then we can pass an order for considering of the.
it was the duty of the, my lord, response number 3, inspectors.
You
my lord,
can always
the
obtain, it is not
principal.
difficult. You can always obtain an RTI. In terms of this order of the court, which you have just placed.
Hmm.
You could have obtained an RTI from the school head principal. That this was the direction. When did you comply with that? And when you have issued, give us the
my lord,
number.
that part will be.
Why we should burden this department? The case is yours. The petitioner has to establish his or her case first.
Yes, my lord, but this As per
What is
the,
the reason you have not filed any contempt petition against that order, non-compliance of that order?
earlier one contempt petition was filed, but
Then what
on,
happened?
Again,
Contempt petition against
Order to
non-compliance of this order or for what?
one,
For law, that was some repetition of that, double one to.
List on Friday. Along with the records of WPC number 601/2017. See, you have to assist the court for its, if you're doing like this.
no, already this review
You
petition is
should,
filed.
For review, you have to give us something, right?
Contempt order 9.
For 601/2017 disposed upon 31/05/2001. Take back your order,
My lord,
Friday,
or on Monday,
okay, Monday, Monday.
the fixed item.
It will come.
Oblige me.